to the notice of the chairman and his management and the commissioners of a particular group of people, of a community that may have been underserved and most often than not unnoticed, but play a critical role in this country, that they have the potential to also elevate the development of this nation, because India are cesspools of intelligence, of potentials that can also add to this great nation. And who are members of this community? Those members are our inmates, people in incarceration, people that have found themselves on the other side of the law. Anywhere I go, I try to let people know that anybody can be in that community. So we need to be careful on how they are treated. We need to extend some of the rights that are also granted to people that are in the open society, because that place is an open-ended society, my prof. So the inmates of this great nation, I represent them as the Controller General of Corrections, over 81,000 of them, of which over 66% are awaiting trial persons who are presumed innocent until proven guilty. Even while as convicts or awaiting trial persons, they do have rights. And part of those rights are rights I'm here this morning to discuss with the INEC chairman to see how we can, if possible, extend some of these rights to these inmates. And this right is about voting rights, my prof, sir. I'm here following a court ruling on the voting rights of inmates in Benin that also escalated up to the appeal court, and there was judgment on it. Of recent, there's also a National Assembly resolution trying to let us know that these people have inalienable right to vote. That for the mere fact that they are in incarceration, we should not deny them the right to vote because they are citizens of this great country. I'm here, Chairman, sir, to see how we can escalate these decisions. Look at the nitty-gritties, look at the gray areas, look at the technical aspect of it, of this court ruling, so that we won't be found not to obey court orders.
We are aware that the right to vote is actually a human right, which cannot be taken away from a citizen on account of time being served in a correctional facility. In many parts of the world, including some African countries such as Ghana, Kenya, and South Africa, where our officials observed elections, inmates exercise the right to vote. The Commission is aware of the judgments of the Federal High Court in Benin, delivered on 16 December 2014, and the Court of Appeal, also in Benin, delivered on 7 December 2018, pertaining to the right to vote by 5 plaintiffs awaiting trial. Based on the combined provisions of Article 25 of the International Convention on Civil and Political Rights, 1966, and Section 25 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, on citizenship, the court affirmed the rights of the plaintiffs who were inmates awaiting trial to vote in elections. However, the judges in the 2 judgments ruled that the right to vote is only exercisable when asserted, as it is a choice to be exercised voluntarily by a citizen and not a duty to be imposed by force of authority. You may recall that in recognition of this situation, the Commission had several discussions with the Correctional Service on how inmates who wish to register and vote in elections can do so. When we set up a joint committee involving both INEC and the Correctional Service, We tried to look at all the nitty-gritty issues and technically review what is involved and the way forward. You availed us of data on the locations and types of federal correctional facilities nationwide. You also provided us with statistics on the various categories of inmates, the majority of whom are on remand awaiting trial, who may actually be registered voters. For our part, we raised the issue of access to the correctional facilities for voter registration, creation of polling units, and voter education. On behalf of stakeholders and for transparency, we also brought to your attention concerns about access to your facilities for observers and the media. Political parties also want to know if they will be allowed to campaign in the correctional facilities and appoint polling agents on election day. We believe that working together with you and the stakeholders, we can address these concerns. As we are aware, election is a process governed by law. Again, working together, we can seize the opportunity of the ongoing electoral reform for a clear legal provision that will specifically cover citizens serving time in our correctional facilities. Doing so will clarify the provision of Section 12, subsection 1E of the Electoral Act 2022 on voter registration, a precondition for voting in elections, which is restricted at the moment to Nigerian citizens who are not subject to any legal incapacity to vote under any law, rule, or regulation in force in Nigeria. There are various interpretations as to whether this provision relates to inmates on death row or those serving life sentence or those convicted for treason. Our immediate task is to engage the National Assembly for a clear legal provision on inmate voting. Thereafter, we can address the specific issues that may arise in the course of implementation.